If you don't know me already, I'm Aziz. I'm a family law solicitor at Bexley Beaumont. These are my contact details, so we'll move swiftly on. So what I thought I'd do was I thought I'd explain about family law because most people know what family law is and the basics of it, but it's always helpful for people to know a little bit more detail based on what scenarios people may be facing or people they know may be facing. So we'll start with the first one, which is obviously the most commonly known, it's divorce. So divorce has actually simplified a lot since 2022. Previously, we you could only start divorce proceedings on one of a number of grounds: is unreasonable behaviour, which was a catch-all. So you could literally say anything in there. I once had a client who wanted to, basically, her and husband had happily parted ways, but I said if you use unreasonable behaviour, you've got to you've got to give a decent reason. And she said, well, he doesn't like football. I said, well, you would have known he doesn't like football when you got married. That's not going to be significant enough for a judge to grant a divorce. You're going to have to come up with something better. And we'd always be able to come up with, especially as lawyers, come up with some sort of mealy-mouthed thing to define the unreasonable behaviour. Then you had the easier ones. You had adultery. Now, adultery was interesting because adultery actually means someone actually has had sex with somebody of a different sex. So that was very difficult to prove if someone disputes it, unless you have an admittance or you have some sort of video or photographic evidence, which has happened in the past actually. And then you had 2 years separation and both parties agreed, or 5 years separation and you didn't need the other's agreement. So there were ways of doing it, but they were slow and potentially ambiguous because what would often happen is one of the parties would say, well, hang on, you've said that I do this in the house. I'm very upset that you've said that now. And the whole process of dealing with the finances and the children would become sidetracked by these relatively petty disputes about the reason for the divorce. So the Law Commission basically looked at it and said, yeah, actually, it's not fit for purpose in the modern world. We're going to have a no-fault divorce system. So now, literally, you can divorce your husband or wife and you don't have to give a reason, or you can even do a joint application, which again, it just reduces the tension between the parties. And it means that rather than concentrating on a relatively small issue of the administrative element of the divorce, you can then concentrate and move on to other things. So it's actually been a very good development in the law. So rather than being obsessed with the reason for divorce, you just crack on with it. So there's a difference though between a British or an English and Welsh domestic divorce case and an international divorce. So you probably would read from time to time in the press that you do get some big divorces, especially in London. And the main reason for that is England is considered an extremely favourable destination for the poorer spouse in a marriage, normally the wife, but not always, by no means always, but often, to divorce because the courts have been historically extremely generous, especially in terms of, for example, maintenance. But what will happen is it will often trigger, for example, a wife from Russia or Saudi Arabia will start divorce proceedings in London, and the husband will then magically start divorce proceedings in, I don't know, their home country, for example, Russia or Saudi Arabia. And depending on how well connected they are in those countries, you'll be shocked by the speed of which they can progress a divorce. There was a judge in Saudi Arabia called Judge Sami Al Sheikh, and his nickname was Judge Sami Al Check because the rumor was if you gave him enough money, he'd basically give you whatever you wanted within 24 hours. Now, unfortunately, I did have a client whose wife was involved in proceedings with him, and women's rights aren't necessarily highly protected in Saudi Arabia, but that judge put it this way: he very well protected her, but it's very clear that money would have changed hands, and that is not necessarily a disaster though, because English law has obviously become quite sophisticated over the years. So even if a party has technically divorced in a foreign country, the other party can still potentially get a financial order in the English courts. So it used to be that you had to have significant connection to England before the divorce in the foreign country had taken place. For example, staying here, or at the very least, having a property that you've lived in England. Now, for good or bad, there's been a recent case in which a wife and her husband divorced in Russia. They didn't really have much connection to England, but the wife decided then to move to England. And about 3 years after moving to England, she decided she wasn't very happy with the Russian finance deal and the divorce there. So she started financial proceedings in England, even though she'd never lived in England before the divorce. And it went all the way up to the Supreme Court, and the Supreme Court decided, actually, yeah, we'll let you get a financial order in England. So I wouldn't say it's opened the floodgates, but it certainly means that there probably will be a lot more work for divorce lawyers from foreign nationals coming in and trying to get a financial order in England, even though they have very little connection to this country. And then we move on to finances generally in a divorce. So, you know, people often say to me, how does the court look at it? You know, if I've been married to my wife for a few years, you know, how will the court start to unpick and unpack the marriage? And I often say, well, one of the primary things the court's going to look at is how long the marriage has lasted, okay? And when it looks at how long the marriage has lasted, we're not just looking at the date you got married. If you lived together before you got married, and that was what we call seamless. So let's say you started living together in 2010 and you got married in 2018. As long as between 2010 and 2018 you didn't break up and live separately, the court, when you come to get divorced, will basically say, when we look at the finances, the marriage started in 2010. And why is that important? It's important because the court looks at 8 years as a long marriage. And why is a long marriage important? Because at that point, the court says the capital should be split 50-50, but the other parties can still present reasons why it shouldn't be 50-50, but the starting point is 50-50. So it's quite important for many parties to get to that 8 year period. Sometimes you'll get a client who says, I've been married for 6 years, and then they hear your advice and they magically go away and they appear 2.5 years later. The sort of cynical thinking does emerge from time to time. Here I've put needs trump all. It's nothing to do with Donald Trump. It is, the court says if a party has needs, I don't know if they're disabled or their earning capacity is severely reduced for whatever reason, and for example, if there are children, if you may all hear of people who've said, well, my wife ended up with 80% of the assets in the divorce and it wasn't very fair. Now, objectively, it might not be very fair, but in that case, it's likely that there was a very limited pot of money and the court decided for whatever reason that the poorer spouse and or the spouse with children, their needs had to be met first. So the other party was considered secondary. A lot of people get very upset, mainly husbands, at that prospect, but that is the law as it stands. There's been one very significant change recently, which is probably very important, especially for those who work in financial services, if their clients ever mention this. Recently, the court has decided even if on a long marriage, let's say you've been married for 25 years, but one of you had a property before marriage worth £1 million, £500,000, and the rent has never been shared with your partner or used for the family outgoings. The property's never been put into joint names or mortgaged in joint names. On that basis, the law currently is that property would be kept outside of the marital pot. So it would not considered to be shared with the other party. Apart from, back to my second point here, needs trump all. Potentially the court could invade it based on needs, but it's a very significant development because it's no longer just automatically starting point is 50-50 even on a long marriage. So the final point there where I say the court will look at capital, income and pension, these are the three headings that we look at. So obviously capital is money in the bank, property, investments. Income is to do with, sorry, I'm getting emails. Property to do with, sorry, income is obviously going to relate to maintenance, and maintenance can be spousal maintenance for your partner, and also it can of course be child maintenance. You can mix and match the two, and we then call it global maintenance. Pensions, pensions can be divided, and the most common way of doing that is what we call a pension sharing order. So if you have, for example, an NHS pension and it's worth £400,000, and we agree that your spouse is taking £200,000 worth of pension, literally £200,000 is carved out of that pension and put into a new pension for you. So they're the three basic ways, or three basic asset classes in which we deal. And also, there's a misnomer in some ways about assets being held in one party's name or in foreign countries. The English court will look at assets in the marriage, whether it's in joint names in one party's name or in the other party's name. And also, it looks at assets worldwide. So we'll make orders about assets that you have in China, for example, or in Africa, but the obviously the power of the English court is limited. It can make an order about assets in a different country, but it can't necessarily enforce it. We then move on to talk about a relatively niche area of family law, which is called Schedule 1. This is additional maintenance that wealthy people can pay. Now, I say wealthy people, since I've started this job about 20 years ago, and the criteria for starting a Schedule 1 claim was that the non-resident parent earns at least £156,000 a year. Now, a bit like the sort of some of the inheritance tax thresholds, this threshold never really seems to have gone up. It was 156,000 about 20 years ago, and it still is. It's obviously 156 is still a good income, but it's nowhere near as good as it was 20 years ago. So this area of legislation is mainly used when parties are not married, but they've had a child together. And for example, the child lives with the mother, and the mother says, well, I need additional top-up maintenance for whatever reason. I've been involved in multiple cases regarding this, for example, with Premier League footballers or with wealthy bankers. Some of the Premier League footballers have literally had a one-night stand, and the mother, shall we say, has what I regard as the lottery of life. So they'll be looking at very substantial sums of money, 10 to 12,000 pounds a month, just in child maintenance. On top of that, they'll probably receive a property to live in. The property will revert back to the paying party when the child is probably 21 or 22, and on top of that, they'll get an allowance for a vehicle and potentially carer's allowance. So for some people, it has been a huge life-changing windfall. And without casting aspersions on people, sometimes you think, well, this was a very, very convenient set of facts here, and I'll move on from that. But it has definitely happened where some people have probably been manipulated into having a child, and the financial results are in their minds quite disastrous because they're paying out, basically millions of pounds over the next 22, 23 years. Then we move on to, I don't know what we're doing for time, Dave, but
Doing okay.
good. We move on to prenuptial agreements and postnuptial agreements, and these are very, very popular at the moment and very important. So I would say to you, if you do know anyone who's planning on getting married, it is very important that they consider getting a prenuptial agreement if they have pre-existing assets, and or if they already had a divorce and, for example, have children from the previous marriage, or have children generally that are not shared with the person that they're marrying. So they are not automatically legally binding. And what I mean by that is there's no act of parliament that says if a prenup is done, it will be automatically enforced by the court. But what we have is case law has developed where senior judges have dealt with cases regarding prenups, and we now have a sort of pattern that, if followed to some extent, the court is likely to give great weight to a prenuptial agreement if it comes across one. So what does it mean to have been properly done? Well, obviously there has to be no duress. Each party has to enter into it from their, of their own free will. You didn't, put your fiance's arm behind her back and force her to sign. That has to be clear. Each party has to have independent legal advice. That's easy to deal with. You get the lawyers to sign a certificate on the back of the prenup confirming that. There must be disclosure, and some clients of mine always get alarmed by this because they don't really want the other party to know what they have. And I have to explain to them there's no way that the other party can enter into a document that is considered by you both as legally binding if they don't know what your financial position is to start with. It's just simply a non-starter. So to protect against someone claiming they didn't know what the financial position was, I make both sides prepare an annex to the prenup, just one or two sides of A4, which summarizes each of their financial position. So neither party can come back down the line and say, well, I didn't know what their financial worth was. Now, of course, occasionally you do meet clients and you're thinking to yourself, not entirely sure you're fully disclosing everything, but unfortunately that's beyond my remit, and they'll have to deal with the consequences of that down the line if the spouse realizes or challenges it. The other important thing is a prenup should be signed. There's different dates people say. Some people say 21 days before marriage. I'm very safety conscious, and I say a prenup should be signed at least 28 days before parties marry to ensure that there's been enough time for consideration. There is some case law which shows prenups that are signed within that period were still accepted by the court, but that's because they were already drafted and the parties were toing and froing. But I once had a client who wanted a prenup done 6 days before he was getting married, and I said, your wife will never sign this within this time period, and I'm going to charge you an awful lot of money to drop everything and send it to her. He said, okay, that's all fine. Sent it to her, and then she refused to sign it. He married her anyway, but it was a good move by her not signing that. We then move on to what are called non-molestation and occupation orders. So these are what we call protective injunctions, and you can actually go to court and get a non-molestation order without the other side knowing, as long as you can convince. It's called without notice. So as long as you can convince the judge that you go in front of that it's so urgent, and if you told the other side that you were doing this, but they could come and get you before the order is granted. And the first they will know of it is when they're served with it by a process server. And non-molestation orders are very helpful because you should also, as good cause, you should lodge it at the local police station as well. And if they're breached, you don't normally go down the court process. If, for example, the order says you're not to telephone the client and you do, they'll call the police, and literally the police will just come and arrest you and you'll go through the criminal court process. So it's a very, very severe sanction if you breach it. An occupation order is where you have a situation where you're both living in the same house and have what we call matrimonial home rights, but you're facing domestic abuse and you want the right to live in the property alone until the divorce is dealt with or until some point in time. Unfortunately, that, in my opinion, is open to very significant abuse, because what I often tell clients is, for example, a wife might come to me and say it's intolerable living in the house with her husband. He's awful. Now, he might say the same about her, but the point is he's not actually being abusive in any way. And you have to explain to the client that there's no way to remove him unless, of course, he's arrested for something in the house and then he's bailed while the police deal with it. Then you might be able to also apply for an occupation order. And that has been, in my opinion, I've had multiple people come back to me and say, oh, my husband, when he walked past me, he moved his shoulder towards me and I felt he'd assaulted me, so I called the police. Now, of course, the police have a duty to investigate this, and while they're investigating, the husband won't be allowed, well, normally the husband won't be allowed back in the house under the bail conditions, and then the wife will often go and seek an occupation order as well. So, a lot of the time they are genuine, but they have been, certainly in my opinion, misused in the past. Then we have children proceedings. People often use the terms residence and contact, and they used to use other older terms as well. Every sort of 10, 15 years, a court changes the wording. Now we have lives with orders, and they use the term spends time with. So, for example, lives with the mother, spends time with the father. People become absolutely obsessed with the wording. Um, you're actually spending with someone, they become obsessed where I want to live with order that says the child lives with both of us. And they'll actually spend tens of thousands of pounds arguing the point when it really doesn't mean very much. Other issues relating to children, you can apply to court, for example, for specific issues about medical treatment or the school that your child is going to go to. I once had a client who his daughter was a very, very talented artist, and she got a full scholarship to a very expensive private school. He was a well-off man. He could have actually paid for it himself if he wanted to. He opposed it and instructed me to make an application to court to say that she should go to a local comprehensive. And the real reason why he wanted to go, because he didn't want to pay. The scholarship didn't include probably about £1,500 a year worth of extras that the parents would have had to pay. And it wasn't a lot of money to him. And I said to him, you can make this application, but judges are very keen on education. Your daughter's got a fantastic scholarship, and there's no way on God's green earth that I can see a judge who's going to say that she goes to the comp rather than the private school. But he insisted. He spent about £20,000 on the process, and I remember the barrister I instructed rang me up and just said, "Is he mad?" And I said, "Yeah, sadly he is." And the judge, probably within about 10 seconds of knowing about the case, had made up his mind and just said, "Well, no, she's going to go to the private school." And I know he actually said to the father, "I know why you're here. You're penny pinching." Although, as I say, the fact that he spent so much on legal fees, it didn't make any sense. But people become very, very odd in these scenarios. Finally, on children, I do a lot with what are called leave to remove cases, where one party wants to remove a child to go and live in a different country. And I always find them exceptionally sad cases, because it doesn't matter how wealthy you are, it doesn't matter your situation. If you live in England and your child lives in Japan, you're going to have a very, very limited relationship with them and seeing them in person for various logistical reasons. It's easier to go what are called Hague Convention countries, i.e., countries which have signed up to the Hague Convention on child abduction. So, if, for example, I have a client who says, "I'm very worried my wife is going to abduct my child to America," I say it's not a problem. Well, it's emotionally a problem, but in reality, if she takes the child to America, America is a Hague Convention country, and there's a process for the child to be automatically returned upon your application back to England. So you're less concerned about these sorts of countries. But if, for example, I don't know, Saudi Arabia, if a father goes and takes the child to Saudi Arabia, then I'd always say to the mother, good luck in basically using the Saudi court process to get the child back. How can I help? Well, that's a very flattering picture of me. I am very, very keen on two elements. That's early settlement and cost consciousness. So all of my clients come from referrals. I've got a colleague who's probably got about a third of my caseload, but she seems to make significantly bill significantly more than me. And it's sad for me, but it's very good for my clients, because I probably settle 90% of my cases. And that's really down to the fourth point there, straight talking. A lot of finance guys in the city, they talk a good talk, and then they're insistent that they'll throw money away on this, they'll spend whatever it takes. But it hits home when I say to them, we can make the application, but it's going to have the same effect as throwing your money into a river. And we're not talking about two, three, £4,000. We're talking 50, 60, 70,000 pounds. And that's coming out of your pot, it's coming out of your children's mouths. And I'm telling you, it's 99.9%. I'm certain that you're not going to be successful. So I do like to be very straight talking with clients, because I know how financially ruinous litigation can be, and also how ruinous it can be for your relationship with your spouse, which will continue to matter if you have children, because Or everyone here who has children, especially children who are sort of beyond 19, 20, know that there are life events where the parents have to still be involved. And if you cannot bear to be in the same room as the mother of the child, then it will impact your child's life even well into their 20s and 30s. So I prefer to advise clients, shall we say, in a firm way not to do it. You can't lead everyone into the right path, but it often works. And I thought, I know Colin in particular likes some of these anecdotes, so I thought I'd add in at the end a few stories that I found funny over the years. I had a client who, on the face of it, had nothing, but in reality, he was exceptionally wealthy. He'd had a he'd had a very brief fling with a lady, and on the back of that, she got pregnant. He decided to do, in his mind, the honourable thing and marry her. And he was very wealthy. He had significant interests in Iraqi Kurdistan and oil interests there. And I thought he's probably worth in the high hundreds of millions. And I remember magically his wife accepted a deal of £2 million sterling and 15,000 US dollars a month until the child was 18, which on the face of it, for any of us, is a good outcome. But, you know, for her, she could have got a lot more. And I always remember I said to him, why the hell has she accepted this deal? And he just simply said, Aziz, all she can prove is I have the watch on my back, sorry, the shirt on my back and the watch on my wrist. And she knows that, and she accepted the deal. And there've been no problems with the deal ever since. She just accepted the reality, rightly or wrongly, she accepted the reality, and you know, she's lived a comfortable life since. The second story is I had a client whose father was a member of parliament in Russia, and in my experience, almost every member of parliament in Russia is there for two reasons. One, either they're a crony of Putin, or they have immunity while they are members of parliament. So his father was a member of the Russian parliament, but every time the client came to see me, he declared that his net worth was significantly lower than what he told me the previous time. And on, for example, the fourth meeting, he said, I've basically got nothing left other than his house in Chiswick. And I said, well, we've got your Ferraris. He said, yes, I remember the Ferraris. And then he came back to me the next week and said, I've had to sell the Ferraris because I pointed out to him the week before, well, if he didn't have any money left, with no respect intended, I couldn't pay him. So he said he'd sold the Ferraris, but as it turned out, he'd just given them to his friends, and literally he brought in bags full of cash and said, can I pay you with this?" And I said, "Well, no, I mean, we can't accept more than £5,000 in cash," and there was about 40,000 in the bags. So, yeah, he was sort of actively laundering money before my eyes, and in the end, we did part ways with him because it's simply not worth it with, you know, when you get to the point of clear money laundering, and it was simply not worth it. The final story there is a client who was a marine biologist. Well, he'd done a master's in marine biology, but not gone into the field. He'd gone into the city, did very well as a financier in the city, and he'd married a lady from Madagascar. They'd had three children, and they were getting divorced. And unfortunately, it did turn out the client was properly bonkers. He came to me and said, Aziz, number one, he said he'd gone on holiday in Ibiza, decided to kill himself, swam out to sea, and just lie there, but then realised he wasn't going to drown because he could float. So that made me think, I'm not sure of your entire credentials as a marine biologist. Then he said to me, I've got a master's in marine biology. I've got a revelation. I said, what is it? He said, I'm convinced that my husband was born a man. I said, right, but you have three children. Were you present at the birth? He said, I was, but I'm convinced that something happened and I've been tricked. And my wife was born a man. And I won't go into it, but what was the conclusion of the final story? They got back together. So he was a very interesting character, and as I say, I'm not sure how much he actually knows about marine biology or biology because he was entirely convinced his wife was a man, despite bearing three children for him.